abide by the rules. You've seen that, haven't you? That actually it's an offence not to comply with those rules. That people have been known to break them. It's very, very unusual, but it occasionally happens, and people can get punished for it. And that's all in the document. I'm mentioning it not as a threat, far from it, but to underline really how important these rules are. They protect the process, they make the trial fair. Second emphasis is the importance of your verdicts being based on the evidence you hear in court, and the importance that you don't do any research into the background of the case or around the case. What you hear in court is what counts, and that only. And so you mustn't, as I say, do research. The next thing is the importance that the verdicts are yours and yours alone. No discussion with anybody else about the case. It's the 12 of you, or 13 as you now are, but ultimately 12 of you who will bring in the verdict in this case, you and you alone. So very important you don't discuss it. Very important that the outcome of the case is the outcome decided by you, the 12 of you as you will be, and nobody else. It's very important that, therefore, that you are on your own in your rooms. And I know that you've been asked about that already, haven't you? You've been asked, haven't you, are you alone? And you've all said that you are. Good. I believe you, and I won't take the matter any further. Because of the nature of this trial, because we're not all of us in the same place, doing it the way that we are, there are one or two particular rules that we need to be conscious of, rules really of behavior more than anything else. It's important we don't, any of us, people in fancy dress like me, witnesses, and you when you're having your discussions at the end of the case, it's important that we don't try to talk all at the same time. That's important because systems like this work in that way. One person's talking, then only that person can get heard. And if two people are talking, nobody gets heard. And the thing is compounded to some extent by the fact that there's a time lag, which makes it a little more difficult. So what am I saying? Will all of us have to be polite and courteous in our speaking to ensure that when somebody else is speaking, we're not. That applies to me as much as anybody else, but it is important. The other thing is to do with concentration levels. The experience appears to be that it is a little more difficult to maintain concentration in this sort of environment when you're looking at a screen. The result of that is that you will get a break during the course of the hearing. I mean, there may be one or two involuntary breaks for whatever reason, but a break you will get. I propose to give it to you at the end of the prosecution case and before the defense case starts. So you'll get that anyway. But if any of you needs a break, comfort break, whatever it might be, would you let me know? And you know how you can do that. The chat line is that a line of communication directly between you and me and nobody else. We're the only people who have access to it. So if you've got a problem, let me know. I can see whether a message has come through. If you've sent one and I haven't responded to it, it's because I haven't noticed on the screen that you've done it. So get your hand up and wave at me or whatever, which will draw my attention to it. But a break, as I say, you will get, but if you need one, you must let me know. The other aspect of concentration is the danger that afflicts all of us of drifting off. I can see you and I'll be able to see you throughout the whole trial, so I ought to notice if any of you drifts off. If you do, will you forgive me if I without in any way humiliating you or identifying you, I really won't, but say generally time to wake up, as it were, just to bring you back into the room if it should happen. I hope you'll forgive me if I do that, and understand that I will not do it in any way that's humiliating to any particular individual. Almost done. Just a quick word about assessment of witnesses, which I know presents potential problems to at least some people, and I actually fully understand it. Is to do with assessing witnesses, whether they're truthful or reliable, when you're not in the same room as them. Demeanor, I suppose, is the topic. I'd like to do my best to reassure you about that. Certainly in the courts where I have presided, it has been always my habit to invite witnesses to sit. I've never understood why witnesses have to stand in court. It's difficult enough just being a witness without the added problem of having to stand uncomfortably and exposed in that way. And I think judges generally are more sympathetic to witnesses in that way. So that the jurors in the normal environment actually only see the head and shoulders of the witnesses that they're going to be assessing. And that's absolutely true in cases where witnesses, as they commonly do these days, give evidence from a location that is not in the courtroom over a video link from somewhere else in the building or from some other distant location. So that's the view that jurors generally get of the head and shoulders, but they get it at some little distance because generally the jury box is at some little distance from the jury box. Here, well, you can see it. You're looking at the screen. You can see me, you can see the clerk, all of us, head and shoulders. And I would have thought actually see us rather better than you would across a crowded room.
Your Honour, we're missing a juror.
Yes. Can we just check if jurors can still hear us? No.
Which number juror? So,
I think it was juror number 4.
Number 4.
So Catherine Johnson.
We may have achieved the pruning of the jury already. Aha, back again.
Juror number 4.
Yeah.
I just ask, when your video dropped out, were you able to still hear?
No.
Okay. So we'll have to just go back over from the point that it dropped out.
Yeah, okay. This sounds like a kind of test, and it's not meant to be. What was the last thing you heard me say?
You were talking about demeanour and how you typically in a court you would see head and shoulders.
Well, then you're up to speed. All I went on to say was, no, that's great, thank you. All I went on to say was that the view you'll get in this virtual environment, I think, I mean, you'll make your own judgment, but actually is as good as, if not better than the view you get in court. But I think there's an even more important point, which is that there's an awful lot of research that demonstrates that demeanour can actually not help in an accurate assessment of truth or reliability, but can actually be misleading. And I won't give you the lecture, but it's a lot of it to do with cultural assumptions. But a lot of people culturally have been brought up to believe that if somebody doesn't look you in the eye, they're not telling you the truth. But there are other cultures where looking people directly in the eye has got nothing to do with that, but it's to do with respect. And that is regarded by some people in some cultures as disrespectful to look people in the eye. And so if you judge a person from that culture as being untruthful because he or she won't look you in the eye, you're just completely misjudging. Plenty of other examples. And people are always nervous in court. and nervousness itself has an effect on demeanour. The research seems to show that what actually matters is what people say rather than how they say it. And to judge people by what they say, looking at whether what they say is internally inconsistent, whether they said one thing at one time, another thing at another time, or is at variance with other evidence which is plainly true, or which runs counter to everybody's knowledge of the world, well, that sort of evidence is likely to be untruthful or unreliable, not because of the witness not meeting your eye or whatever it may be, but because of the evidence itself. You might want to test that hypothesis by reminding yourselves that we have in our jurisdictions internationally people who are entrusted to assess witnesses, judges, magistrates, sometimes jurors, who are blind. And these are people who are correctly regarded, as being as good at assessing truthfulness and reliability as people who are sighted. And sorry, I've said this so many times before, forgive me saying what's the first time to you. If you're in any doubt about that, I suggest you spend 10 or 15 minutes in the company of a blind judge, magistrate, whatever, discussing the topic. And I suspect after that 10 or 15 minutes, if you had a contrary view, you might have changed your mind. Anyway, there we are. All I say is that if you are in the demeanour matters camp, that's fine. You're perfectly entitled to be there, and I wouldn't try and talk you out of it. But if you are, you will be able to see the witnesses. If you're not, then you will be able to hear and assess them. Or if you think there's a bit in both, you have the benefit of both. Sorry, again, a long diatribe. What I'm trying to say is that you will have every chance properly to make a proper assessment of the witnesses. I really am virtually done. It's about devices. You've been asked, haven't you, to switch off devices other than the one you're currently using, and asked not to be able to access your emails and so forth on your device while the trial goes on. You know that. I won't take up your time on that. I just want to add to it, which you may or may not have been told, but to give it force, it's absolutely forbidden to take any sort of photograph, whether by screenshot or otherwise, or to film these proceedings. Don't ask me why. I could tell you, but the underlying reason is that it's just against the law. There are very strong laws about it, and you mustn't break them. That's the lecture. Sorry it's taking so long, but these are important matters. Now, Mr. Trafford, who prosecutes the case, is now going to tell you, I think quite briefly, what the prosecution say the case is all about.
Your Honour, thank you very much. Members of the jury, same thing, please. If you can't hear me or have any difficulty at all hearing me, just raise your hand. And of course, you are directly in front of me as I'm in front of you, and I will be able to deal with that, I hope. I'm prosecuting this case, as you know, not only because I was introduced by the judge a moment ago, but because I have the title underneath my head and shoulders of prosecution. And my learned friend, who is to the right of my screen, and I suspect to the right of yours, Miss Rosina Cottage, is defending Mr. Hallett, the defendant in this case, who, as you can see, is in the middle of your screen and will essentially remain there in your eyesight throughout the course of this trial. Members of the jury, this case, as you know from the indictment, the charge that you have is an assault case. I'm not going to deal at this stage with the law in relation to assault, because it probably to some extent speaks for itself, but it is also an area in this case that is solely in the domain of the judge who has just addressed you, and later on in this case will tell you all about the law. It's my job, members of the jury, to give you a snapshot, a summary of what gives rise to you being where you are and the defendant being where he is today in this trial. Members of the jury, on Saturday the 17th of June 2017, some time ago, The victim in this case, Stuart Sellen, went with his brother Richard to a football match in Wembley. And members of the jury, it's when they came back from that football match later on during the day, just around about 7 o'clock in the evening, that this event took place. And let me tell you how this took place, again, in short, if I may. Richard was driving back from Wembley, and he lives in Pimlico, centre of London, essentially near Victoria Station. And just before he got home, he decided to fill up his car after this relatively long journey to Wembley and back, and he pulled into a petrol station on the Vauxhall Bridge Road. Stuart, the victim, his brother, was in the passenger seat, and Richard got out to fill the car up, and shortly after that, Stuart decided to get out and stretch his legs. On the other side, members of a jury of the petrol pump that evening, a four-wheel drive convertible car pulled up, and it was bellowing very loud music from the car. The defendant had been driving that car, and the defendant got out of the car, filled up the car, whatever he was doing, went to the shop to pay for what he had done, leaving his Aunt Colette, the name you have heard already, Colette Aylett, in the car. Stuart Sellen took exception, for some reason, to the very loud music early that summer's evening, and said something along the lines of, "Why didn't you turn it down? Why is it so loud?" Something like that. Colette Aylett said very little to him, if anything, when he asked her that, and pointed towards the defendant, who is in fact her cousin, as he was coming back. The conversation effectively repeats itself, albeit the defendant said at this stage, "What's it got to do with you? What are you doing? Why are you doing it?" And there was, I think, what would be fair to describe as a remonstration between the two of them. Fairly short, fairly inconsequential, swear words certainly being used, we say, by the defendant against the victim, Mr. Sellen. And then, members of the jury, the defendant got back into his car, and he, to all intents and purposes, to anyone looking, drove off. But very shortly after that, the defendant stopped the car. And this was, it could have been 5-10 metres, something like that away, just before he got into Vauxhall Bridge Road, the road that was going to take him 5 minutes home to where he lived. And members of the jury, Mr. Sellen remained by the petrol pump, out of the car, and the defendant got out of his car to go and remonstrate once again with Mr. Sellen, having driven away. But members of the jury, on this occasion, he took something with him. He took what is called a wheel jack. Now, this is a solid steel, 12, 15, something like that, 30, 45 centimetre, whichever is your preference, out of the car. And he was carrying this heavy piece of kit with him as he approached Mr. Sellen. And once again, there was a remonstration between them, and the defendant grabbed Mr. Sellen's throat. There was, as you will readily understand, I'm sure, there was shouting between the two of them. Richard Sellen, in fact, began to come over from the kiosk where he had been buying the petrol for his car, trying to calm things down. And I'm sorry, that wasn't successful. The defendant carried on. And in fact, by the time Mr. Sellen came over, he used that wheel jack to strike, to assault, to hit Mr. Sellen in the face. And he then continued to do so. He hit him in the face, he hit him in the body, and he hit him with the wheel jack once again. Now, members of the jury, this, of course, happened in a very short period of time, 5-10 seconds, something like that, before finally another person, perhaps with the help of Richard Sellen, the victim's brother, managed to drag the defendant off. And members of the jury, whilst this was going on, albeit it was a fairly short episode, someone had got round to phoning the police and, in fact, called 999 and phoned the police and an ambulance. And very quickly, members of the jury, after this event, with everyone still in the garage area, the police and the ambulance turned up. And the ambulance, having seen the condition of Stuart Sellen, he was bleeding relatively heavily from a wound just above his left eye here, took him off to the hospital just round the corner, in fact, the Westminster Hospital, and leaving the defendant and his cousin in the company of the police. And the police, as you would expect, arrested the defendant and took him to the local police station, Belgravia Police Station, where later on, once this defendant had a solicitor present with him, they interviewed this defendant. And I won't go into the details of the interview now because you're going to hear it a little bit later on in the course of his trial. We've got a summary for you, which I will read out for you. But members of a jury, in essence, what this defendant says was it was Mr. Sellon who was the aggressor. It was Mr. Sellon, the victim, who was rude to his aunt. It was Mr. Sellon who was patronising towards him. But what he did accept, members of the jury, in the course of this interview is he was driving away. He was driving away to go home when he then decided to stop the car, get out of the car, and go back to Mr. Sellon. He was, if you like, and he used the word himself, provoked, members of a jury. But when he went back to the car, he does accept that he picked up. He said he happened to have it with him. It happens to be in his lap, he said. This vehicle, Jack, when he went back towards Mr. Sellon. And again, he continued in the same vein, you may think, when you hear his interview. He then said, he having gone back to Mr. Sellon to remonstrate further with him, it was Mr. Sellon, he says, who was the aggressor towards him, and he and his brother attacked him. And in fact, he said the defendant, he, Mr. Hallett, was only defending himself. Now, members of a jury, those are the very, very short facts of the case. I'll say one area of law, and I've indicated to you already, haven't I, that law is a matter for His Honour, the judge. Facts are the matter for you. Of course they are. But just so you know at this stage, and you keep it very much at the front of mind throughout the whole of this case, it's the prosecution that bring this case, as they do in all types of criminal courts across the country, virtually, physically, Crown Courts, Magistrates' Courts, anywhere else. It is for the prosecution to prove the case, and the standard to which they have to prove it, when you consider your verdicts, can be summarised very simply. The standard of proof in criminal cases are so that you are, members of a jury, sure of your verdicts. And so having, as I've indicated, just very briefly outlined some of the law and briefly outlined the facts to you, I'm now going to call, subject to juror number 13 being released, I'm going to call my first witness, who I've told you all about, Stuart Sellon.
Thank you, Mr. Trafford. Okay, we've retained all 13 of you, but we don't need all of you, as I indicated earlier. Juror 13, forgive me for the impersonal titling of you. That's all I know you as, I'm afraid. Thank you very much for your patience. I suspect you may be observing this trial in another capacity when I release you, but you're free to go so far as your jury attendance is concerned. Thank you very much indeed. So I think that you will understand the technicality. I think, do you mute yourself out of all of this? Is that it? Okay, thank you very much indeed. Thank you.
Yes, you're right. Call Stuart Sellon.
Stuart Sellon, thank you.
Just to let you know, when the witness comes in, my video will go off, but I'll still be here.
Thank you, sir. Your Honour, thank you. May the witness be sworn, please.
Yes.
Jerusalem, please take your holy book in your hand and read aloud the words of the oath with which you have been provided. If you prefer to affirm, will you please read aloud the words of the affirmation with which you have been provided?
I haven't been provided with the words of the affirmation.
Do you want to affirm, or would you prefer to take the oath?
If I could affirm, that'd be great. Thank you.
Okay. Would you say after me, I do solemnly, sincerely, and truly
I do solemnly and sincerely and truly
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much. Mr. Sellon, I think we know who you are because people called your name and you appeared. You're Stuart Sellon, aren't you?
I am, yeah.
Good. But before your question, I need to emphasize to you the importance of you understanding that although you're in your own room, in your own space, you are actually in a court of law.
Yeah.
And so this is a serious process, just as it would be if you were in a formal courtroom.
Yeah.
It's been emphasized to you, I know, that it is critical that you are alone in the room.
Yes.
Are you alone in the room?
I am, yeah.
I'm not going to doubt your word, but if I were to ask you to move your device around, would it turn out that you were indeed telling me the truth?
I am telling the truth, yeah.
Yeah, yes, okay, all right, that's what I thought I ought to say. Mr. Trafford, your witness, please.
Thank you. Briefly, Mr. Sellon, I know we've heard your name. Could you give your full name to the court, please?
Yeah, my name is Stuart Sellon.
Mr. Sellon, you are, I think, the brother of Richard Sellon, is that right?
Yeah, that's correct.
And I think on, and Your Honour, I'm told I can lead this. I think on Saturday the 17th of June, you and your brother went to see a football match in Wembley in North London.
Yeah, that's right.
I just want to ask you some questions about something that happened on the way back, please. So I think your brother was driving, is that right, on the way back from Wembley?
Yeah, correct.
And not far from his house near Victoria Station in London, I think you had to stop and he had to stop to fill up his car with petrol on Vauxhall Bridge Road.
Yeah, that's right.
And were you in the passenger seat?
Yeah, the front passenger seat.
Thank you. When he went into the petrol station, Mr. Sellon, I think he got out to fill up the car and then went to pay. Is that right?
That's correct, yeah.
And I think there came an occasion when you decided to get out of the car yourself.
Yeah, to stretch my legs, yeah.
Yeah. So I'm just going to deal with the events after you got out of the car, please. When you got out of the car to stretch your legs in that garage forecourt, did you see anything that attracted your attention?
Yeah, almost at the same time as I got out of the car, a big 4x4 open top car came and pulled up alongside us to fill up as well. And there was really loud music being played from that car. So that's what I noticed.
Thank you. And who was in that car when it pulled up, please?
I think there were two people, the driver who was a man, and then a woman who was about 40-ish in the passenger seat, I think.
Thank you. Your Honour, there's no dispute the defendant was driving the car when the car pulled up. Thank you. Did there come an occasion when you spoke to somebody in the car about the music?
Yeah, the man had walked off after he'd done the petrol, and then the music was still going on really loud, so I just asked the woman if she could turn it down.
And did she say anything to you, or did she do anything as a result of you asking her to turn the music down?
She didn't say anything. She just pointed at the guy who'd been driving, who was by this time coming back towards the vehicle. So he didn't say anything to me.
And thank you. Did he say anything to you?
He didn't seem very pleased. He said, was there a problem or something like that? I said that the music was too loud, and then he was swearing under his breath, muttering, and then got back in his car. Because of the swearing, I said maybe you should get some manners, but then that was it.
So just give us a sense. He was swearing, but loud enough for you to hear.
Yeah.
And then he got back in the car.
Yeah.
Did he drive? Did he then drive away? Did the car then drive away?
It pulled off a little bit, and through the window I could see that the driver, the guy who'd been swearing, was he was like fiddling with something in the car, but I couldn't see what it was from where I was. And then he drove about 10 yards. He jumped out of the car again.
All right, just pause there. Two things. This was a convertible car, wasn't it?
Yeah, it was open top. Yeah.
And the roof was off it.
Yeah, it was. That's how we could hear the music. Yeah.
All right, thank you. So he then drove away. Did he drive away towards the exit?
Yeah, he was going to the road.
Yeah. And how far from the exit was he? Was he when he stopped?
Not far. Meters, like 10 meters.
All right, thank you. So then what happened, please? He stopped the car. Just help us with what happened then.
Yeah, and then he jumped out of his side, and he was clearly quite wound up. I noticed that he had like this metal spanner type thing, about 10 inches long. It might have been a spanner. It could have been something else, but it was metal because it was shiny.
Well, let me help you with that if I can at the moment.
Yeah.
Please, Mr. Sellan. I'm going to ask you to look at a picture of something, and also members of the jury, in fact. You've been given what I'm going to call a bundle. In fact, of course, it's a sort of virtual bundle of documents, and they have numbers on them. And I hope you've all got that in front of you now. And please do, of course, in the usual way, raise your hands if you haven't. Splendid, that's good news. What I'm going to do is invite you to open up number 2, which is called graphics.
Mr. Trafford, I don't think the judge has been able to access that.
But I've seen them before, so I can probably survive. But if somebody at some point can just point me in the right direction. Don't worry, on you go. Don't worry about me. So
look, I'm going to ask the jury if they open up graphics, and they should then see, when they open that up, on the front page, a document titled AVMI, Case of R versus Christopher Hallett. And then I'm going to ask you to scroll down. You know what I mean by that, members of a jury, I'm sure. You'll go past some injury photographs. I'll come back to those in a moment. And you're going to go down to page 7, as well as you, if you could do that yourself, Mr. Sellan. All right, does everyone have page 7? I see some thumbs up. Mr. Sellan, you see that photograph. Was that the object?
I think Juror 11 is still trying to access it.
So, Madam Juror 11, let me take you through that again, just to confirm we've got it. So it's number 2 of the bundle you've got.
Your Honour, I think Mr. Hallett wishes to say something.
I also don't have the bundle yet.
Okay, Mr. Hallett, what I will do, I suspect you've seen this already, haven't you? It's just you haven't got it at present. Okay, I think we need just to make progress, but if it does become a real problem for you, please raise your hand again, and I'll give you a chance to talk to Miss Cottage about it and anything else you need to discuss with her. Is that all right?
Yeah.
I think we've just...
Thank you. If I can just go back.
Hang on, Mrs. Trafford. Miss Trafford, wait. Miss Cottage?
We've lost a juror.
Yeah, thank you.
And we've lost juror number 1.
Yes.
Yeah, okay. Well, let's just pause for a moment. Yeah, we're back again.
Yes, thank you.
Juror number 1, forgive me. Juror number 1, sorry again to be so impersonal. You haven't missed anything. We stopped the moment you disappeared.
Thank you.
Good. Okay.
Splendid. Thank you very much. Juror number 11, again, forgive the impersonal comment, number 11. Do you now have the bundle I've referred you to, madam? And do you have page 7 on it? Thank you very much indeed.
Sorry, Mr. Trafford. The defendant and the judge should now have the bundles in their chat function.
Good, lovely.
Thank you. Thanks very much indeed. Okay, on we go then. Thank you.
Thank you very much indeed. So, a long lead up to a short question, Mr. Sellon. Was that the object, in fact, that the defendant was carrying as he approached you when he got out of his car?
Yeah, I've seen it now. That's what it was.
Thank you very much indeed. So just going back to what happened that evening, you say he got out of the car, he was carrying that in his hand.
Yeah.
What did he then do, please?
So I was still by Richard's car, and then this guy started coming at me. He was shouting things. He was clearly really aggressive. Much more wound up than he had.
Can you remember what he said to you?
No, it was. I don't remember the exact words. I'm afraid it was just general shouting, and then he came right up very close to me, and I was telling him to calm down. But I was really aware that he had that thing in his hand. Richard was still inside the petrol station, and then he grabbed me by the neck, and he was telling me that he was going to take me down. He was going to take the other guy down. I don't know who he was talking about when he was talking about the other guy, and I was trying to push him off me, but he had me around the neck. And then kept shouting, and then I don't know how long it took him, but then he hit me with that metal wheel clamp thing on the forehead.
Just stopping you there, two things. Did you hit him at all at any stage in the course of that early part of the connection between the two of you?
I was trying to push his arms away because they were around my neck, but I don't think I hit him. It was trying to defend myself.
All right, thank you. And where you talked about him then hitting you across the face? Is that right?
We've lost
Wait,
another.
stop. We've lost.
Just going to pause there for one moment. Number 4.
Yeah. Are you back with us, number 4?
Back, sorry.
No, don't worry. It's not your fault. It's perfectly okay. We paused the minute you disappeared, so you haven't missed anything.
Yeah, okay.
Thank you.
If this happens again, forgive me. If this happens again, I won't keep saying you've missed nothing. Just trust me, the minute you go, we'll stop. Whoever it may be. Okay? All right. Yeah, thank you.
To where we were, Mr. Sellon, where was your brother when you were struck across the face, please?
I think by then Richard had come out of the kiosk, and he was trying to get in the middle to calm things down. So by the time I was hit, he was there.
All right. Did he have any success in calming any of it down?
No. That after Richard arrived is when he hit me. So no.
Thank you. Did he hit you once, or did he hit you more times than that?
So the first one, it cut myself, and blood was coming all down my front. And then after that, I think he hit me twice more on the body with that metal wrench thing.
And listen, can you remember where on your body you were hit?
It was just on my ribs on the side.
Thank you. And again, in that second half of that incident, did you hit the defendant, Mr. Hallett, in any way during the course of that?
Just like I said before, I was trying to push him away with my arms, but I don't think I hit him. No, I was just trying to I was just flailing to try and protect myself.
Now this melee came to an end. Can you remember how it was? It in fact came to an end.
Yeah, someone else who was in the garage went over to the man's car, the open top car, and he took the keys out of the car, and when he noticed that, he stopped attacking me and then ran over to get his keys back from whoever that man was.
Right.
That's what stopped it.
And then I think, again, this is agreed, Your Honour, so I can leave this shortly after that. It's right, didn't it? The police and the ambulance turned up in a matter of moments. Is that right?
Yeah. Yeah, well, before the police turned up, the guy who attacked me went to a phone booth and he made a phone call because there was a public phone just on the forecourt. And then not long after that, a car turned up with two guys in it who he seemed to know, and he went over to talk to them. But you're right, fairly soon after that, the ambulance and the police came.
But by the way, I should have asked, did you hear what was said between him and the car that turned up or not?
Yeah, he was still really wound up. He was telling them that I'd been insulting him and calling him all sorts of names, which I hadn't done. But I don't know who those two guys were in that new car.
All right. So the ambulance came up. Did you go away in the ambulance?
Yeah, they took me to hospital.
And thank you. Okay, for those purposes, can I just briefly show you and the jury back to that bundle of documents we've got? You remember that one where we had on page 7 the item that he was carrying? I just want to scroll through very quickly, if I may, members of the jury, Mr. Selland, the graphics there. Can we just go straight to page 3, please? It is obviously not a photograph, it's a representation of you, Mr. Selland. It shows a mark called 01 over your left eye.
Yeah.
Does everyone have that on page 3? Again, if you don't, put your hand up in some way. Is that the injury that was caused by the item he was carrying?
Yeah.
Thank you. Next, please, page 4. We can see what we're going to hear is a contusion to your right middle finger. Is that right?
Yes.
And do you know how you got that?
Not specifically, just in the melee, I think.
Thank you. The next one is page number 5, page 5. Little arrow with number 3 pointing at it in your lower middle right abdomen. Again, can you remember how that happened?
Maybe when he was hitting me. I'm not entirely sure.
All right. And then I'm just going to take you down just so you see it. In pages 8 and 9, really it's for Your Honour's assistance and others, a short and small graphic of the map of the area and Vauxhall Bridge Road, of course. Do you know that area, Mr. Selland, well enough?
I do, yes.
And do you recognise that as being the scene of where this happened?
Yeah, that's near Richard's house.
Thank you, Mr. Selland. I've got no further questions for you at the moment. Miss Cottage, on behalf of the defendant, may have some questions for you. Thank you.
Yes, Miss Cottage. Yeah.
Thank you, Your Honour. Richard had already gone into pay, hadn't he, when the car drew up?
Yes, he had, yeah.
So you were expecting to be in that petrol station for what, another minute? Minute and a half?
Yeah.
So what was the need for you to go over to that car at all?
Like I explained, it was just playing very loud music, which I thought was probably bothering not just me, but everyone else who was around.
But it's a petrol station, isn't it? People are only going to be there for a minute or so. What was the need for you to go over and speak to anybody about music?
It was just really loud, quite antisocial. That's why I did it.
The man had gone off to pay as well before you gone up to the car, hadn't he? The driver.
Yeah.
So why did you wait for the driver to go and pay before you went up to the car?
I guess I was hoping that they would turn it off, and then when they didn't, that's when I decided to say, do you mind turning it down?
You just went up to the woman passenger and leant over the car door right in her face, didn't you?
No, I didn't do that.
And you told her that she was listening to shit music, didn't you?
No, I didn't say that.
Well, what music were they listening to, just out of interest?
I don't really know. It was just very, very loud. Yeah, sorry, I don't know the particular song.
No, well, was it poppy? Was it classical? Was it jazz? What was it?
I think it was probably pop.
You think?
I don't know the specifics.
But it wasn't the music itself then that was upsetting. You just say it was the sound.
Yeah, the noise of it, yeah.
But you could only hear it because the roof was down, couldn't you?
That would definitely have made it worse, yes. I don't know.
The woman that you spoke to, she immediately looked scared of you, didn't she?
I don't think so.
And she started crying, didn't she, within moments?
No, I don't think she was crying.
Because you were threatening and you were abusive about the music, generally, weren't you?
No, I wasn't.
Now, you're a tall chap, aren't you? What, 6'2", 6'3"?
Yeah.
Quite well built?
I like to think so.
Yes. And she was sitting down in a car below you as you leant over her. Yes?
No.
Now, when the man came back, you swore and were abusive to him too, weren't you?
No, I wasn't.
And he was the one to tell you to get some manners, wasn't he?
No, like I explained, he was swearing.
And so he began to drive off, but you were still shouting and swearing at them as they drove away, weren't you?
No, I wasn't.
But had you taken the view that they were Essex common types and that you thought that you should tell them what to do?
No, I didn't take that view.
Because in your witness statement, you said that he was an Essex type, the man, didn't you?
Yes.
What did you mean by an Essex type, Mr. Sellon?
A man who comes from Essex.
Right. And that he had a common sounding voice. What did you mean by a common sounding voice?
Well, I come from Chelmsford, so his voice to me was normal, common, every day.
Right. So he was an Essex type with a common sounding voice. But of course, Mr. Sellon, you don't have a common sounding voice, do you? Or do you?
I don't know. It's not for me to say. I think I sound normal.
All right. But in your witness statement, those were the words that you chose to describe him, weren't they?
Yeah, that's what I told the police, yeah.
Right. So the man got out of the car. He came towards you, but he didn't use the will brace upon you until your brother became involved, did he?
He hit me after Richard came. Yes, that's right.
That's right. That as he was, sorry,
Just pause.
Mr. Hallett.
Yes, Mr. Hallett?
Can I have a word with my lawyer?
Yes, of course you can.
Okay.
Yes?
Sorry, I'm just about to finish cross-examining. May I complete the cross-examination but not ask the witness to leave?
Yes, that's fine. You can reserve your position. Yeah, that's fine. You do that. Okay, Mr. Hallett, you can have your word, but just in a moment. Okay?
All right. Thank you very much, Your Honour.
You happy? Mr. Hallett, you okay with that? Good. Thank you.
Mr. Sellon, what happened is that you continued to shout and swear at Mr. Hallett as he came out of the car to remonstrate with you about your language and behaviour. That's the truth of it, isn't it?
No, that's not what happened.
And that you and he were arguing when your brother stepped in between you.
He was shouting at me. That's when Richard came.
And that it was after Richard came that effectively a melee really started, and that's when you were hurt.
After Richard came, he hit me with the spanner thing. And that's, yeah, I was, like I explained, I was trying to protect myself, but that's when I was attacked.
Weren't you attacking him?
No, he came to me when he got out of his car.
Can you remember how he might have sustained a cut lower lip? Or a black eye?
No, sorry.
Or cut to the back of his hands?
Maybe when he was attacking me, he cut his hands. I don't know, I'm afraid.
Or gave himself a black eye?
I don't know, I'm sorry.
Did you give him the black eye, Mr. Sellen?
No.
You were the attacker, weren't you? And you called him a piece of shit, didn't you?
No,
Two
I didn't
questions,
say
Ms. Gottlieb. Which one do you want answered?
That's it. Well, you were the attacker, Mr. Sellen. Were you?
No, I wasn't. He attacked me.
And you were the one who called him a piece of shit, weren't you?
No.
Thank you. Your Honour, may I have a moment with Mr. Hallett now?
Yes, of course you can. Mr. Hallett, please don't tell me what it is you want to talk to your counsel about. That's absolutely private. But any idea how long you think it might take?
Just a minute or two.
Okay, that's fine. Well, you can certainly have that. Members of the jury, in the usual environment, the two of them will go off into a private place and talk to each other. Well, there is a private place, but it's not a real one, it's a virtual one, and they're going to go there and do that. What I'm going to say is, so that we can all kind of work around it, I'll give you 5 minutes.
Thank you.
This cottage. My device says it's 12:26. So can we please reassemble at 12, I'll say 12:32.
Thank you.
That's to all of us. And anybody who wants to leave the physical space that they're in, they're welcome to do so, but please be back in that physical space in 5 minutes' time, ready to resume. Okay?
Thank you, Your Honour. Of course, we have to leave, but...
Of course you do, but you'll be back with us in 5 minutes.
I will do.
Excellent. Very good. Good. Well, I can stretch my legs too. See you all in 5 minutes. Oh, Mr. Sellen, I should say to you, forgive me, can you hear me, Mr. Sellen? Well done, all of you. You all got back in time. Juror 3, I don't know if you've muted yourself entirely. Can you hear me? Is there a problem? Just to satisfy. Oh, there we are. Well done, all of you there. Can all see? Can all hear? Excellent. Thank you very much indeed. And very good timing to all of us. Scottish, anything more you want to ask?
No, there's nothing further. Thank you.
Okay, thank you.
You're not,
Any re-examination?
Forgive me, I have no re-examination of this witness. Does Your Honour have any questions for Mr.
No, I don't.
Sellon?
Thank you very much. No, I don't. Thank you. Mr. Sellon, thank you very much indeed. I said to you just after the jury had left us, say to you again in their presence, you mustn't discuss your evidence with anybody else who's about to give evidence, which means I think your brother. But is he in the same place as you, or is he in his own place? Your brother.
He's not in the same place as me. No.
He's not. Thank you. Thank you very much indeed.
Your Honour, thank you. And in those circumstances, please, may I call Mr. Richard Sellon to give evidence?
Yeah.
Thank you.
Your Honour, may I check something? My screen appears to be rather pixelated, and I don't know whether there's a view that is pixelated of me by others, or whether that's just unfortunately my view.
Well, I can see you perfectly.
Fine, good. No need to worry. Thank you.
Can you see?
So can I.
Fine.
If anybody cannot see this cottage in the way they wish to, I mean, that's a rather loaded question, isn't it? If anybody can't see this cottage properly, if you can't, could you raise your hand? Yeah. Okay, all is well.
Just to let you know, they're just preparing the witness now, so it shouldn't be too much longer.
Excellent, thank you.
Thank you very much.
Yes, Mr. Sellon, they've been talking about calling somebody called Richard Sellon, and I suspect that's you, is it? Can you hear me?
He's turned
I think you might find you've muted yourself. Can you hear me?
No.
No, fine. Do you know how to... No point asking you, is there really, if you can't hear me?
Ah.
Yeah, don't worry.
Can you confirm? Let's reconnect you in a second.
Yeah, okay. Now, is this any better? Can you hear me? Please say yes.
Thank you.
Good, good. Well, we can hear you too. I think you're Richard Sellon, aren't you? That's the name that people have been, as it were, calling out. Richard Sellon?
Yes, Your Honour.
Good. Well, the first thing is you're going to be asked to take the oath or to affirm. So would you just pause while we do that?
Please take your holy book in your hand and read aloud the words of the oath with which you have been provided. If you prefer to affirm, will you please read aloud the words of the affirmation with which you have been provided?
I do solemnly and sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Now, thank you, Mr. Sellon. But before you give your evidence, it's important that I emphasise to you that although you're in your own physical space, you are now in a courtroom. You understand that, I hope?
Yes, Your Honour.
And that there's a formality and a solemnity and an importance that goes with being in a courtroom, and all of that applies. Good. And secondly, if I were to ask you to turn your, I'm not asking you to, but if I were to ask you to turn your device round 360 degrees, would it show that there was nobody else in the room with you?
Yes.
That's the truth of it. There is nobody with you.
There's no one with me. Yes, Your Honour.
Okay, very well. Thank you very much indeed. Thank you. Yes.
Thank you. The full name is Richard Sellon, is that right?
Yes.
Mr. Sellon, I'm going to ask you a few questions about events on the evening of Saturday, the 17th of June, 2017. All right?
Yes.
So, first, you I think, have been to a football match at Wembley that during the course of a day with your brother Stuart?
Yes, that's correct.
And you came back to your where you live in Pimlico near Victoria Station that evening.
Yes, we were driving back home when we stopped at the station.
And I think on the way you stopped at the petrol station on the Vauxhall Bridge Road, very close to your home. Is that right?
That's correct.
I think you went to fill up the car, got out the car and went to the kiosk. Is that also right?
Yes, that's correct.
Forgive me for taking this relatively quickly. All those matters are agreed, and therefore I can lead them to you. May I just ask you about what happened next, please? Did your brother stay in the car?
When I was in the kiosk, or when I was filling up the car with petrol?
When you're filling up the car.
Initially, he was in the car, yes. But I think he was trying to get the attention of the person in the other car and asking them to turn down the music because they were playing music quite loudly.
And was this a car on the other side of the petrol pump?
On the other side of our car, yes.
Yeah, all right. So did there come an occasion when your brother got out of the car?
Yes.
And when he got out of the car, please, where were you?
I was on the other side of the car, filling up the car.
All right. Did you see your brother, or did you hear your brother say anything to the people in the car?
It was quite loud, so I couldn't hear exactly what he said, but I thought it was something to the effect of, could they please turn the music down?
And when that was said, how many people were in the car, please?
I'm not sure. I only saw one person in the passenger seat.
All right. And just very briefly describe that person.
I could just see a young boy. That was it.
All right. Well, we need not worry about that for the moment. There came an occasion, I think you went to pay at the kiosk. Is that right?
Yes.
And did you then see what your brother was doing? And if so, could you describe what then happened, please?
As I was walking to the kiosk, what I presume was the driver from the other car was walking back from the kiosk to their car, and at that point said something to my brother along the lines of, "Do you have a problem?" I looked back. I saw Stuart and the man talking. I saw the man get into his car and begin to drive off, at which point I entered the kiosk and got out my checkbook to pay.
All right. Did in fact the person, and we know it's the defendant, did he in fact then drive off or not?
He began driving off, but stopped fairly quickly.
And when he stopped, were you looking at him or his car when he stopped?
I didn't see the car stop in that exact moment, but I did see the defendant get out of the car.
All right. Could you just help us then with what happened once he got out of the car? Was he carrying anything, Mr. Sellen?
Yes, but I couldn't see at the time what he was carrying.
All right. Did you see where he went and at what speed he went when he got out of the car?
I saw him walking towards our car, but I thought nothing of it at the time. I looked back down to finish paying, at which point when I looked up, the defendant had reached my brother and grabbed him by the throat, at which point I obviously ran out to help Stuart.
All right. So the first thing you saw was the defendant grab your brother by the throat, which made you run out of the kiosk.
Yes, that's correct.
And when you got to where they were, what was happening, please?
I mean, the man seemed very agitated, and I just wanted to appease them. I wanted to calm things down. He was yelling at us, telling us that we were just posh boys. He was trying to grab Stuart, and Stuart defended himself and tried to push him away, at which point the defendant swung what I think was a wheel brace and hit my brother on the side of the head.
All right. So were you right by your brother when that happened?
Yes.
All right. What were you doing? Were you physically interfering in any way with the defendant when he had his hands around your brother's throat?
No. I was just trying to calm him down, and I figured that if I physically got involved, it would just escalate things.
Right. So just take us that your brother was struck in the face by this weapon that you told us about. What then happened? Did you then get involved?
Yes, at that point, the man became increasingly agitated and started to hit Stuart on the sides of his body, at which point I finally managed to grab hold of him and restrain him. And thankfully, then someone else also intervened.
And just help us very briefly with this. Was your brother standing up or had he fallen down? What sort of position was he in when he was being attacked?
I don't remember exactly, but I think he was standing up.
All right. So you then got involved, Mr. Sellen, on behalf of your brother. Did you manage to stop what was going on?
Yes. Thankfully, someone else also intervened and managed to restrain the defendant, and we prevented the defendant from leaving, and thankfully then someone called the police.
All right. Did you see anyone else arrive on the scene apart from the ambulance and the police, about whom I'll speak to you in a moment?
No, not particularly.
All right. So then we know, I think it's agreed, the ambulance turned up and took your brother off to hospital.
Yes, Westminster Hospital, correct.
And did you hear or see anything that you want to tell us about from the moment that the attack stopped to the moment that your brother went off to hospital?
No, not particularly.
I've got no further questions for you, Mr. If you wait there, Miss Cottage may have some questions for you. Thank you.
Yes.
Yes, Mr. Sellen. Really, just some questions about timing. You had gone into the kiosk to pay whilst all of this was going on. Is that right?
Correct.
And your brother had only just got out of the car as you were going off to pay.
My brother had already gotten out of the car while I was filling up, and he remained outside of the car as I walked to the kiosk.
But as you walked to the kiosk, the other man walked away from the kiosk, as it were.
That's correct.
And that you were able to write a check and pay, and then come back to sort out the problems between your brother and the other man.
That's correct.
There was nobody else in the queue, was there?
Not that I remember, no.
And so the time that you took to go to the kiosk and pay by check or otherwise was what, about a minute? Minute and a half?
Possibly slightly longer. I'm sorry, I don't remember exactly.
2 minutes at most?
Possibly, I'm not sure.
But whilst you were paying, your attention was on paying, wasn't it?
Yes, for the most part. I'm embarrassed to say that my debit card stopped working, so I had to pay by check.
Well, you'd have had to find a pen. Did you have a pen with you?
Not that I remember. I think I used one in the kiosk.
All right. So your attention was on what was going on at the kiosk, wasn't it?
Initially, yes.
Yes. until you were leaving the kiosk to come back to the car. Would that be fair?
That's correct.
And so when you came back towards your brother, you hadn't seen what had started, what was going on between them, had you?
I had heard the man ask my brother if he had a problem, but besides that, didn't hear any specifics afterwards, no.
All right. And you didn't see what started off the two men, your brother and Mr. Sellen, being connected in a struggle, did you? You didn't see what started that?
No.
No. All right. And so when you came in fact, you got in between them both straight away, didn't you?
Yes, as I hope any brother would if he saw his brother being attacked.
All right. That's what your assumption was. Would that be fair? That's all you saw.
Yes, I saw the defendant grab my brother by the throat.
Did you see and hear what your brother was saying before that happened?
No.
No. And when you got in between them, you assisted your brother physically, didn't you? By pushing at Mr. Hallett, didn't you?
No, I didn't need to push Mr. Hallett. My brother was trying to defend himself. I tried to calm Mr. Hallett down, and I intervened after he hit Stuart on the side of the head.
In fact, you intervened before your brother was hit over the head, didn't you?
No.
Passenger in the car was in fact a middle-aged lady, but just to remind Your Honour, I know it may have been said by someone else that the passenger was a middle-aged lady. That, of course, is agreed by the prosecution.
Yeah.
So, if Your Honour is content, I can read a short.
Well, I tell you what, actually, just thinking on my feet, as it were.
Yes.
Quite soon, I was going to take a break. Why don't we do that now? The break that I promised the jury in my introductory remarks. Why don't we take that now and use that time to resolve the issue? I'm asking the question. I'm actually answering it for myself. That's what we'll do.
All right.
Members of the jury, I had intended to give you 20 minutes for a break, but you've had 5 already. So I'm not going to enter into some negotiation with you. And honestly, if I said 15 and you all say that's outrageous, I need longer. Anybody wants to say that you need longer than 15 minutes? Would you be okay with 15? You're all okay.
I see.
No, let's be realistic. Okay. It's 12:56 by my device, and therefore is that at 12 minutes past 1. Yeah.
May I invite you on to say this?
I did basic arithmetic when I was really young, but it might be 12:56 and 53 seconds. Yeah, what?
Your Honour, may I invite you on to say this, that it might be easier if the jury leave their feeds open rather than the way as if they left the jury box and merely walked out. That may...
Well, that's what we did last time. That's what we'll do this, yeah. Yeah.
Splendid. Sorry to interrupt. Yeah. Thank you.
Okay. That's not at all. So whatever time I just said, see you then.
Thank you very much.
Okay, bye.
No, enough fines.
we've lost a juror.
Juror number 10.
Can you hear me now?
Yes.
Good, I muted myself. I was going to say that some of you plainly brought a mug of something in with you, which we wouldn't normally permit in a courtroom. But for two reasons, I actually encourage you to drink out of your mug here first, because we're not physically in a real courtroom, which is quite an important reason. But the second really important reason is that I've got a cup here myself that I want to drink out of. So we will allow ourselves that indulgence. So please don't feel in the slightest bit embarrassed. Good.
Well, Your Honour, that leads in, I think, to me reading the interview whilst people enjoy their tea.
Yeah.
I hope it aids concentration rather than detracts it.
Well, it'll keep me awake at least, Mr. Trafford.
As you always would be, Your Honour, I know. So,
okay, on we go then. Yeah, good,
Your
thank
Honour,
you.
the defendant was interviewed at the Belgravia police station on the 18th of June, the day after the event, about midday, 12:23. Now, members of a jury, I'm going to invite you to follow this whilst I read it. And so can we do that exercise we did again earlier, but this time go to a different, if you don't mind, document. All right? So bring up what you had earlier, and you can go to item 3 on this occasion, and the title, if that's the right word, the note, it says R-O-T-I, Roti, C. Hallett, number 3. Can I just make sure you've all got that? I see various different methods, some nods, some thumbs. I think I got full thumbs bar juror number 1 has been, hasn't said whether she's got it or not. A full hand from her. Thank you very much indeed. So
a thumbs down from me again, Mr. Trafford. That'll be remedied, I'm sure. Don't worry, don't worry. Just saying.
You're on the interviewing officer PC Wells, and one will see where it says other persons present that the defendant had his solicitor with him. And Your Honour will forgive me, most of this is in summary. It's been agreed by the defence.
Good.
Mr. Hallett is CH, if we look to the left-hand side, and he describes taking his cousin back to London and pulling into a petrol station and noticing an Audi on the forecourt, where he filled up with petrol and paid for it. And he noticed a tall white man, 6'4", blonde hair, leaning against the car, yelling at his cousin. And Mr. Hallett went back and says, what's up? Mr. Hallett then says, next to 333, that Mr. Selin replied, you're a stinking yob who smells of shit. He says, quite shocked, I just laughed it off, really. I then noticed my cousin for the first time. He was crying. I'm going to jump to the next bit, if I may, because he then says at 5:16 that he started, that's to say Mr. Selin started leaning over the car and was using foul language, which made him very edgy. He had been assaulted before. And then he moves on and says this after the officer intervenes. He says, I'm not a violent man, never assaulted anyone before, you should know that. To carry on, he said, his presence was very menacing towards me. At this point, I had my seatbelt on the car, I was strapped in the car, and it was hot, the windows were down, I felt he was going to hit me as I was being abusive back to him. He then said this, to deter his actions, I took a tool kit which is inside the car and describes how the car is manufactured with the toolkit being inside the car. And from there, I grabbed the first object that was in there, which happened to be a spanner. Placed it on my lap, resting it on my lap. I thought this might deter him, but he carried on using bad language. Mr. Hallett then described how he started to drive away. He said the man continued to shout abuse, and the other man called him a yob with no balls. He said he felt provoked, so he stopped the car. And he states he had the wheel brace in his hand simply because it had been lying in his lap. He then said this: when I got close to him, he attacked me. I tried to push him away, but he carried on wrestling with me. I could see that another man had joined him, trying to beat me up. I realised now that this was the brother of the tall man. It was only then that I lashed out. I gave him what he was asking for. I didn't want to fight. He provoked me. I did nothing. Mr. Hallett then described how he was struggling and the wheel brace was still in his hand. When he was asked about his injuries, that's to say Mr. Hallett's injuries, he stated his lip had been cut, his back had bruised and his kidneys hurt. A doctor had examined him in the police station. The officer asked, when you drove on to the police petrol station, was the music in your vehicle playing loudly? Mr. Hallett said, not excessively loudly. It was loud, as in the fact it was a cabriolet car with the roof off and the music is audible. And then his own solicitor intervened and said this. He said, I think it is right that you should know, in any event, that my client was listening to Beethoven's Ninth. The officer then says, it's right before, therefore, that because you felt you were being abused, you lashed out at the complainant. He said, yes, but he was being assisted by his brother. I had no one. My cousin was still in the car. And the interview ended, and that was a summary of it at 13:05 that afternoon. And that is the case, Your Honour, on behalf of the prosecution.
Thank you, Mr. Trafford. Ms. Cottage?
Thank you, Your Honour. Yes, I call the defendant, please.
Yep, thank you.
Mr. Hallett, would you give your...
No, wait.
Oh, he needs to be sworn. I'm so sorry.
Mr. Hallett, do you wish to swear or to affirm?
To affirm, please.
Please do that. You have the card, I think, in front of you, do you?
Yeah, I have the words.
Good, thank you.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
I say this to you as I've said to all the other witnesses. You do understand that these are formal proceedings, serious proceedings.
Yep.
And I know that you're obliged to tell us if, and you know this, if you're not on your own. Are you on your own?
I am, yeah.
Again, if I asked you to turn your device through 360 degrees, would it prove that you are on your own?
It would.
Okay, very well. Thank you.
Thank you, Thank you, Anna. Mr. Hallett, would you give your full name to the court, please?
Christopher Hallett.
And on the day that we've heard about, had you been at work?
Yeah, I've been just finished work. I was coming away from my father's laundrette business, our family's laundrette business.
Right. And you had another person in the car with you. Who was it?
Yeah, that was my aunt, Colette.
All right. And she's roughly how old? You don't need to reveal her a specific age, but roughly how old is she?
She's in her 40s.
Right. And what were you going to do?
I'd finished a long day at work, and I was just sort of winding down for the evening, and I was just dropping Colette back home, I think, and then I was going home.
Right. Now, were you playing music when you drew up at the petrol station?
Yeah, we had some classical music playing. Yeah, there was music playing in the car.
Was it very loud?
No, not particularly loud, I wouldn't say. It was classical music, so it rises and falls sometimes, but it wasn't loud, and it certainly wasn't obnoxious or rude in any way.
Right. So you went to the petrol station and went to pay. And what's the first thing that you noticed, please, when you came out of the petrol station?
Oh, I came out of the door of the petrol station and was coming back towards my car, and I noticed this really, really large guy, and he was leaning far into the passenger side of the car where Colette was sitting, and he was just he was screaming in her face, and he was being really, really aggressive and sort of manic. He was just really, really manic.
All right. What was he shouting or screaming about? Could you tell?
I mean, I couldn't tell originally at first, but it seemed that it was something to do with the music, and he was just levelling lots of abuse at Colette for the music that was on.
All right. Abuse can mean any number of things. What kind of language was being used?
Yeah, a lot of bad language, a lot of nasty words towards her, and she was really upset. She's quite timid, and she's had a long illness for all of her life, and she was really taken aback, and she was crying, and she looked really stunned and upset.
All right. So what did you do?
I went up to him, and I went up to where he was standing, and I asked what was going on. I asked for an explanation, and as soon as I did that, he turned around, and the first thing he said was, "You're a stinking yob, and you smell of shit." And I was just taken aback. I couldn't believe he said it for no reason whatsoever. So I just tried to ask him to calm down and just get some manners.
Right. And where were you? So were you the driver's side and he still at the passenger side, or had you got closer together? Where were you each?
Well, no, originally I came back from the shop to pay, and he was leaning far into the car, and then I had to pass the passenger side to get round to the driver's side. So, I passed him, and I asked him what he was doing while I was still outside the car. And after I asked him that, and he had said that abuse to me, then I went round to get into the car.
All right. And you got in the car, and what happened next, please?
Well, I got into the car, and I sat down, and he followed me around to my side of the car, to the driver's side of the car, and his behaviour was really erratic. And I don't know if it seemed like he'd been drinking, because he didn't seem normal or in full possession of himself. So then he started leaning far into my side, and he was screaming these obscenities in my face, like right in my face. He's saying that you're a yob with no balls, and you're a lower class turd. And he just said, yobs like you just shouldn't be here, and you shouldn't be fouling up the air. And he just kept shouting this at me and at Colette while we were in the car.
All right. And so this was going on. Did you do anything? Did you say anything to him, or did you do anything as a result of this tirade of abuse?
Well, I was quite frightened, because he was a huge guy. He was about 6'4". He was much bigger than I am. I'm only 5'9", and he was really well built, and I'm not. So the car's a 4x4. It's sort of like an off-roader car, and down by where the gearbox would be, it has a small toolkit. So I was still looking at him, but I just put my hand down to see if there was anything there. So I just took the first thing that came into my hand, and I lay it across my lap to try and show him that I had some means of protecting myself, even though he was much bigger than I was. I thought maybe that could, he might sort of back off.
All right. And then what did you do?
Well, then he kept shouting at me, so I just wanted to get Colette away from where he was. So I started the car, and I tried to move it away. I couldn't move it at first because he was right in my face, and it was quite intimidating because Colette was right there as well, and she was very upset. So as soon as I could, I just moved it away a little bit, and he just kept shouting this abuse at me, the same stuff he'd said: "You're a yob, you shouldn't be here, you're lower class, you smell like shit." And so I got away from where the pump was, and then I thought the situation shouldn't end like that. I should ask for an apology or something for Colette, because he shouldn't be allowed just abuse her like that and abuse me. So I was hoping I could end the situation with some sort of dignity, or just have him apologize for what he'd said. So I stopped the car, and I got out, and I was hoping I'd be able to reason with him a little bit. So that's what happened then.
All right. So when you got out of the car, what did you do with the wheel brace?
Well, I had the wheel brace across my lap from where I'd put it to try and just show him that I had it. So I stepped out of the car to my right, and it kind of I took it with me, sort of. I didn't deliberately take it with me. It was on my lap, and as I stepped out, it just sort of came with me. So I had it in my hand, and I was just hoping to get an apology from him. But as soon as I got out, he walked really quite quickly towards me, and then he just lunged at me. So he lunged at me and tried to start hitting me, and I was holding him off in the chest. He was much taller than I was, so I was had my hand up, to sort of on his chest, which was higher than where I would normally reach. I was just trying to keep him at arm's length to stop him hitting me.
Right. And then what happened? So you're fending him off, and then what happens?
So I'm fending him off, and he's hit me in the back, and hit me in the kidneys, and I had a lot of injuries after that. And then the next thing I know is I'm still trying to just hold him away from hitting me. And the next thing I know is that another guy was right there. I now know that it was his brother, and he was equally as big as the first guy, and they were both much bigger than I was. So I thought I'm in quite a lot of trouble here now, and my arms began to flail, and I just wanted to fend them off in some way. So yeah, my arms were flailing, and just against the two of them. There was two of them against me.
All right. Now, did you use the wheel brace, or can you remember whether you did?
No, I didn't. I didn't use the wheel brace in any sort of deliberate fashion at all. It was in my hand inadvertently because I tried to show him that I had it, and I hadn't meant to hit him. I just meant to fend him off. And then when there were two of them, my arms began flailing. So I don't know what happened then.
Now, when all of this was over, were you examined by a doctor?
Yeah, I was.
And you had, and I don't think there's any dispute about this, Your Honour, you had a cut lower lip, a black eye, and cuts to the back of your hands. And in the interview, you spoke about soreness to your kidneys and your side as well.
Yeah, so there was soreness to my back because he was punching down on my back. I heard him say that. Pardon?
Which one are we talking about? He was punching down on your back. Which one?
The first one was originally Stuart, and then I guess both of them were. I heard him say also that I had him around the neck, which is completely ridiculous because he was much, much taller than I was. There was no way I could possibly have him around the neck. So I mean, yeah. So they were just landing punches on me from both sides, in my abdomen and on my back, and that's where my injuries were, as well as a black eye and a lip.
Thank you. Your Honour, there's a matter of law that I'd like to raise just very briefly, if I may. Something that occurs to me that I should raise with you in the absence of the jury, if I may. That's possible.
Okay, thank you. Now, in the ordinary way, the jury would, as it were, be taken out of this virtual space. But I'm going to ask a technical question, which might make the thing quicker. Can the... Oh, no, this doesn't work. I'm sorry. It doesn't technically work. Okay, Manager, I'm going to have to ask that you be removed out of the courtroom space into your virtual space.
And Your Honour, that's done. But
wait, please wait. Before we do that, can you give me some broad hint as the general area that this relates to, or would that be unhelpful?
It would be unhelpful, but it is very, very brief.
Okay, all right. Okay, Manager, I'm sorry, we're going to have to do it in that way. Can the jury briefly be taken to their virtual space and then almost immediately brought back into our space? Yeah, good, that's been done. Thank you. Yeah.
Thank you. I'm sorry, but of course it hasn't been raised with me, and the prosecution hasn't made their application, and nothing has been said about the defendant's previous convictions. And it
Well, I'll tell you what I think the answer is, Ms. Cotter. Thank you. I'll hear an argument. Can I help you with my provisional views to that? Your client has asserted to the police that he's not a violent person, which creates what is at least arguably a false impression because he has the conviction that you're concerned with. It seems to be difficult to keep it out.
Well, so be it. I'm not going to argue now, but it was something that I thought I ought to raise.
Well, that's fine. Okay.
Raised, and we have an opportunity to see that this does work in the absence of the jury as well.
Well, yeah, quite. Thank you. I propose to give the jury a direction that really takes the sting out of it, but nonetheless, it seems to me that it is admissible. You will doubtless want to lead it yourself rather than leave Mr. Trafford to make more of it than it perhaps merits. Okay, that's fine.
That's why we chose it. Thank you.
I'll make nothing of it.
Thank you.
All I mean is that these things sometimes assume greater weight as the subject of cross-examination than they do as the subject of examination in chief. I mean no more than that. Okay, jury back then, please.
That's an interesting point. Ooh.
Okay, looks like we're coming back in.
Right.
Good.
Okay.
Welcome to a Cisco meeting. Welcome to a Cisco meeting.
It'll just take a short minute for them to come back in, so just be patient, please.
Thank you, Your Honour.
Good. Thank you. All back. You can all see, you can all hear.
Yeah.
Excellent. Good. Yes. Ms. Gottlieb. Thank you.
Mr. Hallett, just one or two questions now, just as we come to the end of the scene, as it were. So the brothers come in, you think you're under attack, and there are two of them. How did it come to an end?
I can't remember exactly. I think they were just hitting me, and it just ended per se. I think maybe the second brother tried to fend off the first brother. I can't remember exactly. Sorry.
All right. And then the police became involved, and we've heard that you were interviewed with the presence of a solicitor. Now, there's finally one other subject that I'd like to ask you about, is that you have one previous conviction, is that right?
Yeah.
And that was 2 years ago for threatening words and behaviour.
Yeah, just threatening words, that's right.
That's right. And that was at the Magistrates' Court.
Yeah.
Thank you. And you've never been in trouble for anything else, have you?
No.
Thank you.
Ms. Cotter, sorry to interrupt, but just for clarity, there are different ways of committing this offence.
Yes.
Sometimes by using threatening words, sometimes by using threatening behaviour, sometimes by both. My understanding is that your client's conviction is for using threatening words and no more than that.
Which is what he said. Yes, sorry,
Yes,
I should have just confirmed with him. He said that it was threatening words, which is correct. There was nothing more to it. Thank you.
Yeah, thank you. Yeah, thanks very much indeed. Thank you, Ms. Cotter. Mr. Trafford, you can take this pretty shortly. Mr. Trafford, you can take this quite shortly, can't you? Your case is absolutely crystal clear.
Your Honour, thank you for that invitation.
No, it's not an invitation, it's rather stronger than that.
All right. Thank you for whatever it was. Mr. Hallett, words to your counsel only 7 minutes ago were these, that after that initial confrontation where you both swore at each other, you said this: I wanted to get Colette away. Do you remember saying that?
Yeah.
And you had the clear opportunity to do that, didn't you?
Yeah.
You had Vauxhall Bridge Road, which leads you 7 minutes away to your home by turning left. And you could have got in your car and driven your aunt away from a man you described as manic and screaming that left your aunt stunned and upset. Couldn't you?
Yeah, but I mean, that's missing the point completely. So if...
And what you chose to do, Mr. Hallett...
Could counsel allow the defendant...
Yes. You must allow to answer, Mr. Trafford.
So the situation was that this guy, Mr. Selm, had caused severe upset to my aunt. She was crying. She was really upset. He'd been very intimidating, very aggressive. So yeah, I could have just driven her away, but that wouldn't have been the end of the situation, and it wouldn't have been the proper way to leave the situation. I was hoping he'd apologise to her. She's very timid. She's very upset. She's had a long illness, and I thought the better way to leave the situation would be to try to get this person to see reason, a brief apology to her, and then I'd leave.
John, I won't labour that point about wanting to get Colette away as a result of your invitation. You then did begin to drive away, but then you chose to stop, didn't you?
Well, I chose to drive her away from the immediate scene, which I did a few metres away.
And then when you chose to get out of the car, you chose to take a wheel brace with you, didn't you?
No, I didn't choose to take a wheel brace with me. I chose initially to put the wheel brace across my lap so that he could see I might have some means of defending myself, even though at that stage he was leaning far into the car and he was much bigger than I was. When I got out to later ask him for an apology, then it was in my lap. So when I stood up out of the car, it came with me. I hadn't left it back where it was.
It came with you, Mr. Hallett?
Yeah, precisely, yeah.
You chose to take it with you, Mr. Hallett. It didn't come with you willy-nilly, did it?
Well, it was lying across my lap, so I stood out of the car. I mean, there had been no violence in this situation up until that point at all, so I had no reason to believe that there might have been, even though Mr. Sound had been behaving very aggressively. So it was irrespective whether or not it was in the car or not. It was just, I'd lain it across my lap, and when I got out of the car, I had it in my hand.
You had it in your hand because you chose to take it with you to carry on the aggression, didn't you, Mr. Hallett?
The only choice I made was to lie it across my lap to show him I had some means of defending myself. After that, the movements were kind of involuntary, quite frankly.
How long into that 5, 6, 7, 8, 10-metre journey from your car back to the pump, how long was it before you realised, gosh, I've got a large, heavy wheel jack in my hand as I'm going to get an apology out of this man?
Well, it wasn't very long at all, because I stood up out of the car and Mr. Sellon walked very quickly towards me. In the end, he lunged right at me, so I didn't have very much time at all.
You said this, didn't you, in your interview, just for reference, 8:38, when I got close to him, you, Mr. Hallett, went to him. He didn't come to you, did he?
I mean, I don't know. That just seems to be splitting hairs.
You went to him with a jack in your hand.
I stood up out of the car. That was what I did. He also came to me.
When you could have driven away.
I mean, that's just, you're just presuming that the incident was violent at that time, and it hadn't been violent up to that point. I had no reason to believe it would be, even though he'd been very aggressive. So I was just asking for an apology.
And you said to this jury one moment ago, in answer to your learning counsel's questions, you said, I was hoping, and this is your words again, to end this with dignity. Do you remember that expression?
Yeah. I mean, it was he had been very disrespectful to my aunt, and it was no way to treat her. She'd been innocently listening to music, sitting in a car, getting filled up with petrol, and she'd just been abused that day, and then so had I, and I didn't think it was a proper way just to to walk away from that situation. I tried to get him to see reason.
So where is the dignity of a man like you leaving a car like that?
That's an argument. Well, that's an argument, not a question.
It probably is.
Yes, no, not probably. It is.
The short point is, Mr. Hallett, and I'm sorry to cut across his honour, of course I am, that you went back to attack this man because you were the aggressor.
Totally wrong. He was absolutely much, much bigger than I am. He looked like an athlete. He was much stronger than I was. He was about 7 or 8 inches taller than I was. To suggest that I would go and attack him is just, it's ridiculous.
You and I don't think repetition adds to weight.
No, that's very clear. Thank you very much, Mr. Trafford. Thank you.
Your Honour, I have no re-examination, thank you.
If I just ask one question, because that's something I'm struggling with and the jury might be too. Mr. Hallett, you told the jury you went back to get an apology. Yeah?
Oh, yeah.
The question that I kind of struggle with, I'm really interested to know your answer to it. Did you actually think you would get an apology out of a man who had behaved towards you in the way that you said he had?
I mean, perhaps that was a little bit naive, but he had just, even as I moved the car away, he'd just been levelling so much abuse.
Well, I understand that, but
yeah, I just
the question was a different one. Did you actually think you would get an apology from him?
Yeah, I mean, it was 7 p.m. For me, it was 7 p.m. on a Saturday after a long day's work. I mean, I was in a reasonable frame of mind. Perhaps he wasn't.
I'm going to interrupt you again. I really don't mean to cut across you, but it's a kind of yes/no thing, isn't it? Did you really think you were going to get an apology?
Yeah, I think I would have. Yeah.
Okay, that's fine. And you've explained why, and I understand that. Okay, that's helpful. Thank you. Ms. Scott, is there anything you want to ask arising from that? Please do.
No, thank you.
No. Okay. Thank you very much. Thank you, Mr. Hallett. Scottish, there's a witness, I think, who wants to talk.
Yes, I do. Please, Colette Aylett.
Right.
And just put me on the witness. If there's any delay, it shouldn't be very long.
Thank you.
Good. Thank you. May the witness be sworn.
Oh. Good. Mr. Aylett, would you either take the oath or affirm? Have you got the card and materials in front of you to allow you to do that?
Yes, I have. To affirm, please.
Very well, thank you. If you read the words on the card.
I do solemnly and sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
You'll forgive me for saying this to you, but I've said it to every single witness so far, so I say it to you also. You are aware that although you're in your own private space, you are actually in a court of law.
Yes.
And this is a formal and serious process that we're involved in here. You understand that?
Yes, I do.
And secondly, you know that you must be alone in your room as you give your evidence, not permissible for there to be anybody else there with you. You never know whether I might make you do it or not. If I asked you to turn your device through 360 degrees, what would that show us?
There's nobody else in the room.
Okay, then I won't make you do it. Thank you. Yes.
Miss Aylett, would you please give your full name?
Yes, it's Colette Aylett.
Thank you. And you are the aunt of Christopher Hallett, is that right?
Yes, I am.
And we have been hearing evidence about an incident that occurred at a petrol station some time ago in Pimlico. On that day, before you went to the petrol station, had you been with Christopher for long?
No, he'd just picked me up and we were going out, so we were just driving along in the car.
All right. What kind of frame of mind was he in?
He was fine. He was fine. We hadn't seen each other for a while and we were just playing some music. It was quite a happy mood.
Can you remember the music that you were playing?
I can't now. It wasn't to my taste, so I wouldn't know the name, but we were playing it quite loud because we were having a little bit of fun.
All right. And you were playing it loud. Of course, you had the roof down. Was it very loud?
Well, I don't think it was any louder than you hear other people playing music. It was louder than you would normally have if you were just going around and listening to it on your own. But it was quite a nice. We had the roof down and we were singing along. Yeah, so I don't think it was awful.
All right. Now
that you sometimes hear from other people's car.
All right, sorry. I'm going to ask you now about the man who came to speak to you at the car. What happened, please, when he came to the car? What was the first thing that happened?
Well, Chris had just gone to pay for the petrol. We were at a petrol station and he sort of just appeared out of the blue, really. And he was shouting at me about the music and he sort of leaned in. I could smell alcohol in his breath and he was just shouting and it just took me by shock, actually. It was quite unnerving and he was shouting very loud. And then Chris could see what was happening from the pay desk.
All right, well, wait, before Chris,
okay.
The man is shouting at you. Did you respond to him in any way?
I was too shocked to, really. I don't think I said anything. I was just really, really taken aback because we'd been having such a nice time just driving along and having a nice time. And then he just came over. It was, it doesn't normally happen to you that somebody just starts shouting at you in that way. So I don't think I said anything.
All right. But how did you feel about his behaviour? How were you feeling about it?
I felt really... I think I started crying, actually. You just realise when somebody's shouting at you like that, it doesn't happen that somebody's sort of in your face so much. He was leaning over, so it was quite distressing.
All right. Then you mentioned Chris. Now, whatever he heard or otherwise, you won't know. But anyway, you could see him starting to move back towards the car. So when he came back towards your car, what was the next thing that happened then?
He just came over to try and help me, and he was obviously concerned. And he was just trying to deal with this person shouting at me who just didn't seem to be stopping. So he picked up a wheel brace that he had in the car and just sort of waved it at him to try and frighten him away.
All right. Had Chris got back into the car by that stage?
Yeah, he got back into the car and we actually tried to move away then, but we couldn't get out of the petrol station. I think there might have been another car in front of us. And this guy was still shouting, just didn't seem to be calming down at all and sort of hurling abuse at us about the music. And so Chris got out of the car to try and sort the issue out. And then the next thing I knew, I'd sort of turned around and there was a fight in progress. And there were two... the first man.
All right, I'm going to ask you because your wife. Sorry, can you wait there a moment? Your Wi-Fi cut out a little bit, so if we can just rewind. You said you turned around, and you missed whatever was going on, and when you turned back, there were, I think you said, two men with Chris. All right, can you tell us what you saw when you first turned around? Then you saw the two men, and you saw Chris. What did you see?
I saw that they were hitting Chris and he had blood on his face. They were both much bigger and taller than him, so it was really obvious that he was getting the worst side of the argument. And then Chris still had the wheel brace in his hand and he just swung it in front of him, to my mind, as a way of defending himself and getting them to stand back. And then very shortly after that, the police arrived. And that was the end of the fight.
All right. Thank you. Thank you very much. If you'd like to wait there, there'll be further questions for you.
Okay, thank you.
Ms. Saylor, can I just deal with this relatively briefly, please? You're the defendant's aunt?
Yes.
Yep. I think your younger brother is his father, is that right?
That's right, yes.
And you obviously get on very well with him. So after this initial argument, all right, where bad language was used, yes? There was an initial argument about
yes,
whatever the music was. You were singing along, I think, to pop music. Is that right, with your nephew? Yeah?
Yes.
Yeah. And there was an initial argument in which bad language was used. And your nephew then drove off after that, didn't he?
Well, he tried to drive off, but we couldn't actually get out of the petrol station. So that's when he got out of the car.
Well, I think we said that you had a what would be called, I think, a clean run at the Vauxhall Bridge Road, didn't you? You could have gone straight home.
That isn't my recollection. I don't remember us being able to actually leave the petrol station. And we were also just in shock that somebody was shouting at us so much. And I think Chris just wanted to get it sorted out. He's quite protective of me, and I think he was worried that I was crying.
Yeah. So in terms of this, and I use your language, sorting it out, Miss Saylor, what was in your mind when you saw your nephew get out of the car carrying a 30-centimetre piece of solid steel?
I don't think I actually noticed the wheel brace at his side as he was getting out of the car. But I mean, this guy just hadn't stopped. You know, we were asking him what his problem was, and he just continued. And he was really loud. I was upset. I was crying then. So my recollection is that we couldn't get out of the petrol station at that time. So I think Chris was just getting out there to just sort of tell him to stop it, because what we didn't. I don't know what else we could have done. If we'd sat in the car, he would have just continued abusing us, and the roof was down. So it's a bit frightening.
Mr. Traff, I think we all perfectly understand your case, that there is a slight, on both sides, slight feeling of the record's cracked.
Well, I'm sorry.
We understand that. No, it's not being critical, just observe.
No.
The issues are clear. Thank you very much for your...
Well, if Your Honour is satisfied that the prosecution...
Yes, I'm sure the jury are too. Thank you very much. Yeah. Has Gottlieb any re-examination?
No, I have no re-examination. Thank you, Your Honour.
Good, thank you. So, thank you very much indeed for your help. You're now free to go. Thank you.
Thank you.
Your Honour, I have one witness statement to read, please, from a doctor. Thank you. Very good. The statement of Dr. David Gottlieb. I'm a general practitioner and act as an FME, a forensic medical examiner, that is for Belgravia Police Station. On Saturday, the 17th of June 2017, I was called to Belgravia Police Station to examine Christopher Hallett, who'd been arrested earlier that evening. I began my examination at 10:30 p.m. I noted that he had the following injuries: cuts and lacerations on the backs of both hands, a badly cut lower lip, and what appeared to be the beginning of a bruising to his left eye. He was also complaining of pain in his kidneys. On examination, he was tender in that region. I treated him with painkillers and certified that he was fit to be detained and interviewed. I completed my examination at 10:40 p.m. and made the appropriate entry in the medical examiner's book. Thank you. That's the case for the defence. Thank you, Your Honour.
Thank you very much indeed. Okay, Manager, that's all the evidence that you're going to hear. Before Counsel make their, as I anticipate, very brief submissions to you, I'm going to give you some legal directions, which I hope are in your chat line. I keep getting it wrong. You know what I'm talking about. I haven't actually, again, got it in mind. That doesn't trouble me because I've got it elsewhere. But if you go there, is there somewhere there something that says something like legal directions? Can you find something? Yes, please do help. Yes, thank you. Yeah. Mr. Trafford, yes, please.
Item 10.
Item 10. Ah, excellent.
Judge's directions to jury.
Perfect. Thank you so much. Are you all there, and have you all opened that up? Everybody happy? Okay, good. I say I kind of step out of role for a minute to say this, that in the ordinary way I'd have gone through these with you in detail, but because it's important that you have sufficient time to have at least some discussion about your verdict, I'm going to do this really quickly. Okay? These are the legal directions that are relevant. They're in under different topics. Who does what? You decide the verdict. That's your job. You decide where the truth lies in the case, you and nobody else. I give you legal directions and you must follow those, but we have those very different functions. Who has to prove the case? How do they do it? Well, the prosecution have to prove the case, and they do it if and only if they make you sure of the guilt of the defendant. Then there's a lot of stuff about the offence itself, but happily there's really only one word in the indictment that really matters in this case, and that word is unlawfully. It's important to stress that the prosecution must prove that the defendant acted unlawfully. And there, when you have the chance to read it, at paragraphs 4, 5, and 6 is the sort of legal lecture. But can I take you to paragraph 7, which is the bit that matters? These are the questions that you need to ask yourselves and answer. Are you all there? Paragraph 7? Yep. A, did Mr. Hallett, the defendant, actually believe that he was under attack or under the threat of attack? If the prosecution have proved that he did not have that belief, then the question of self-defense just doesn't arise. There'd be no lawful justification for his use of force, and you'd find him guilty. If, on the other hand, it may be that he did believe that he was under attack or threat of attack, that is, the prosecution not proved otherwise, then you'd have to go on to consider the next question, which is, was the amount of force in the circumstances as he believed them to be, and in the heat of the moment, reasonable? And then if you're sure that the correct answer to that question is no, you'll find him guilty. If, on the other hand, you were not sure of that, so you thought that the amount of force used by him may have been reasonable, you would find him not guilty. Those are the questions you have to ask. Central to that, obviously, is the question as to why he ever stopped the car on his way out and went back again armed as he was. You have the prosecution case on that, and you have the defence answer to it. Your deliberations and your verdict, it's only to say to you that somebody must speak for you when you return to court, so you must get somebody to do that. And it's a repetition, really, of the courtesy and politeness thing, not all talking at once, particularly important in this environment. And this doesn't really arise in any real sense, but I can only accept a unanimous verdict from you. That's really it, other than to add that the stuff you've heard about Mr. Hallett's assertion that he's not a violent man in the interview is balanced by the fact that he has this conviction for using threatening words rather than behaviour. And you should use that evidence in this way. The fact that he's been convicted of using violence, that he's never been convicted of using violence, is of obvious importance. Whether its importance is reduced because of the conviction, and if so, how much is for you to assess. But you will also bear in mind that he's not a man who's ever been convicted of any offence involving dishonesty, and you should factor that into your assessment of his truthfulness as a witness. That's the law. Mr. Trafford.
Members of the jury, don't be distracted, if I may say, by the class war that the defendant has put forward for the reason for him attacking Mr. Selland. Don't be distracted, perhaps, by what initially happened about whether it was Beethoven's Ninth, as Mr. Selland seems to imply, or some pop music, whatever that may mean, that his aunt applies. Don't be distracted about anything, members of the jury, except perhaps paragraph 7 of His Honour's directions, which he has given to you, They're on, I think, page 3, and they start with the word unlawfully. The questions you will have to answer. A, did Mr. Hallett actually believe he was under attack or under threat of attack? If the prosecution had proved that he did not have that belief, then the question of self-defence, members of a jury, would not arise. The defendant got out of his car on the way home. He got out of his car after the first, however you find it, incident of people swearing at each other. He had a clear route home, members of a jury, and he chose, when he got out of that car, when he was not under attack, nor was he on any analysis of these facts, including his own, under any threat of attack, he took a weapon with him. He made that choice, members of a jury, and with the greatest respect to the way he put his evidence and anything else in this case, it makes your choice so much the easier. I said to you the burden is on the prosecution. It is. I said to you that the standard is a high one so that you can be sure, and we welcome you to apply that standard in this case, and you can only be sure, members of a jury, in the terms of paragraph 7 of His Honour's directions and what I've just told you about the facts of this case. He chose to go back to attack this man, and members of a jury, in those circumstances, I put this simply, and as I promised His Honour a moment ago shortly, he is guilty of the offence as charged. That, members of a jury, is all I have to say for you, and I thank you for what I think, from what I can see from these small boxes on my screen, is your careful attention to everything. Thank you.
Yes, thank you, Mr. Trafford. Ms. Cottage.
Thank you. Members of the jury, interesting start by the prosecution to ignore the class war. Well, it's not a class war raised by the defence in any way. It's about the truthfulness of the complainant, Mr. Sellen. He was a man who said that he was only going over to ask very nicely to turn down some music. Well, is that the truth or not? It was him in his witness statement who said that Mr. Hallett was a common type, was an Essex type. He was common. So it came from him, but he said, oh no, that he came from Chelmsford. That was just because he was an Essex person. It's about whether or not you can rely on Mr. Sellen and whether or not, in fact, you thought he may be a tall man who thought he could bully the woman sitting in the car because he didn't like the music. No more or no less than that. It all happened very quickly, didn't it? Because we all know how long it takes to get in and out of a petrol station. Minutes. There doesn't seem to have been a queue that day. You were able to move in and out. So it all happened very quickly. And decision-making can be a difficult thing to do at the best of times, particularly when emotions are heightened and particularly in a short space of time. Mr. Hallett was lawfully entitled to stop his car and get out to remonstrate with a man who'd made his aunt cry, who was swearing and being abusive to them both. There was absolutely nothing that prevented him from doing that. No law, poor judgment, but not unlawful. He was lawfully allowed to confront Mr. Sellen, to actually go up and speak to him about his language and his behaviour. Poor judgment, yes. Lawful, yes, as well. So he's entitled to do that. You may say poor judgment to get out of the car, but that was all lawful. If the man was threatening, which he had been, he was entitled to take out the wheel brace as he did. Now, it's a matter for you. If it may be the truth, and only that, if it may be the truth, then when he got out of the car, that as it was on his lap, he just got out of the car and it was in his hand at his side, and he gave no more thought to it because all he was going to do was talk to the man to tell him to stop being so abusive. Then he wasn't doing anything with any intention to harm or to injure anybody at all. Again, poor judgment, but still lawful. He's not being prosecuted for getting out of the car and getting into a row that he should have avoided. He's being prosecuted for causing intentional and unlawful injury to somebody else with a weapon. So that is what you've got to consider. In fact, we say that he was instinctively doing what he felt was necessary when he believed he was being attacked by both men, because it is at that time that you must consider the use of the wheel brace. Not at any time before. You may consider that what happened before might be helpful, but it could be helpful on both sides, can't it? Because we say that Mr. Sellen at all times was the aggressor. Mr. Sellen at all times began the abuse and was the man who wanted to take the aggression further. And so when Mr. Hallett went up to speak to him, and Mr. Sellen was the aggressor towards him, he did nothing more than fend him off. But when another man became involved, you may think any person would feel that they were under attack by two men. They'd got themselves involved in a situation that they could not get out of, and they were now about to be hurt. And that's exactly what Mr. Hallett thought. He thought he was about to be hurt and attacked by both of these men, and all he did was to defend himself in the only way that he thought he could, which is instinctively. He didn't even think about whether he had the bar in his hand or what he was going to do. He just flailed and hit out to try and defend himself. And it was over clearly within moments. If he was intentionally going to hit Mr. Sellen over his head with a wheel brace, he would have done far more damage, you may have thought, than the cut above the eyebrow which Mr. Sellen had, that meant that he could be sent home from the hospital without any treatment at all, and no further harm done to him apart from some bruises. In fact, it must have been, we say, some sort of glancing blow as part of the melee, rather than any intentional and unlawful action deliberately taken by Mr. Hallett. And in those circumstances, if that only may be right, that he was doing no more than was instinctively necessary to defend himself, then we say he is entitled to be acquitted. But we say that you can be absolutely sure that Mr. Sellen was the aggressor, in fact, in this case. Mr. Hallett showed poor judgment, but he was not the aggressor, and he only did what was necessary to defend himself. And I have no further submissions. Thank you.
Okay, Madam Secretary, those are the submissions. There's the law. I don't want to take up your time when really the important thing is for you to embark on your deliberations. But the issue of the case is really not about intention here. The issue is about lawfulness of the use of force. And the question for you to determine in straightforward terms is the broad question: what actually was Mr. Hallett doing when he'd left the car armed with the wheel brace? Was it to get an apology, or was it to engage in violence? And if it was to engage in violence, then any force used by him intentionally or recklessly is unlawful. That makes sense, I hope. Anyway, that's really for you to judge. That's the job you have. I'm not going to remind you of the evidence. You've heard it in a very short compass today, and you were listening carefully, and that's good enough for me. I've been asked by somebody to remind you that one of you must speak for you when you return. I think I said that to you earlier, but I repeat it now, that somebody must act as your foreman, your spokesperson.
Sorry, Your Honour.
When you return to court. Yes.
There's a question for the judge.
I know there is. Thank you. No, I've seen it. Thank you. Okay, I'll read this aloud. Is the defendant guilty if he did not believe he was under attack at the point when he got out of the car with the metal implement, but should have appreciated that it would be obvious that the complainant would feel threatened? The answer is this. that if he got out of the car armed at a time when he was not under threat of attack and did not believe that he was under threat of attack, and subsequently used the metal implement to inflict injury, whether intentionally or recklessly, then he would be guilty. That, I think, follows from the directions that I'm not going to have an argument about it. If I'm wrong, I'm not going to have an argument about it. If I'm wrong,
I didn't wish to have an argument about it.
Scotty, I don't want to be rude to you in the slightest, but I really want the jury to have time to get on with their deliberations rather than for us to have discussions of law. Okay, I'll certainly hear you in a moment and bring the jury back if I'm persuaded I should say something different. Okay, members of the jury, I'm now going to ask you to retire. I think you now go into your own virtual space. Is that right? Somebody will tell me if I'm wrong.
You do.
Yeah, we didn't do this on a previous occasion. That's why I'm asking. Okay, members of the jury, then if you retire, I mean, don't physically do anything, stay where you are. You will be, as it were, retired into your private space. The time is now round about 2:15. What I'd like you to do, please, is to let us know through the chat line if you've reached a verdict on which you're all agreed, in which case we'll bring you back again. If you haven't, we'll bring you back in at about 2 to 3 in any event.
May I make one short point, Your Honour?
You can. I really don't want to take a lot of time chatting. I want the jury to get on with what they're doing. So what is it?
In normal circumstances, a jury bailiff will be sworn in the terms of...
I know all that. Yeah, I know. But we're not doing that.
Thank you.
Okay, thank you. Yeah, okay. Right, thank you, members of the jury. I'm going to ask that you now be removed, not physically removed, but removed electronically to your virtual space. Thank you. And you've gone. I'm really sorry to be so abrupt with both of you.
Of course.
It's fine.
But it's the timing of it. What did you want to say, Ms. Gottlieb?
That I fundamentally disagreed with what your answer to the jury. Fundamentally. However, I'm not going to get into it now.
Yeah, but I mean, we're not here to get the law right. I mean, it was a question of considerable further consideration.
Don't worry.
But I have to say that I do have to say that the trial has hitherto proceeded on the footing that whether your client intended to cause injury or not, he certainly was reckless as to whether injury was caused or not, and so that the element of the offence encompassed by the word maliciously was never an issue.
No. It's just that there are two. Doesn't matter. I'm not going to go into it now. But it's that he says his case is, of course, that he didn't even think about whether he had it in his hand at all. So the deliberate
it's objective recklessness.
I wonder whether written submissions on this would be helpful to be served in, say, 28 days. Because the public gallery is open and having legal submissions at this stage might not be.
But I'm not going to argue about. I'm not going to take it any further because I don't think it matters. I think that today's trial proceeded very smoothly with evidence and timing. Yeah. So I have no further submissions to make.
Thank you. We only lost. I counted the minutes. 6 minutes on jurors.
Yeah, and since we're kind of chatting in this way, the late start was because of a technical problem, but this is replicated in the world we're more familiar with, where an exhibit, for example, is not brought to court by a police officer.
Or the prosecutor has the wrong number of copies, all sorts of things like
all that sort of stuff. Exactly, yeah. So in fact, the delay, although technical, I mean, electronically technical, is absolutely the sort of delay that happens in this sort of case in the real rather than virtual world.
Yeah. Sorry, just to let you know, the public gallery stream is still on, I think.
That's fine. There's no problem with that at all. That's fine.
Would Your Honour wish us to step away from court as if we were going?
What I'm minded to do is to suggest that we mute ourselves now, if there is a jury, I mean, I frankly don't want to sit looking at my screen for half an hour to see if there's a message that they've got a verdict. That will be monitored, will it? Do you monitor that? Don't want to make you sit for.
Yeah, I'll monitor with.
If somebody send us an email to say there is a verdict, and then we can react to that. If there is one,
I'll be back in this room. So
I'm
very happy to call people if the email doesn't get through or something. Would that help?
I missed the very beginning of that, sorry.
Bar 10 minutes, whereas if you're interested in
I see.
a cup of tea...
Is this the 10 minutes that's about to start at this second?
Then I will come back into this room.
Okay.
And if something happens, I will call you and Scott will text you as well, just to make sure you've got both emails and texts.
Okay, that's perfect. Thank you. Good.
I did about
in any event, we must all be back and go time for 10 to 3.
Thank you very much. Thank you.
Your client may keep his bail.
Thank you.
Eric, will you send me an email if they come back? Or how it will work?
Is that okay? That's not imposing, I hope, a great burden on you, or is it? Is that okay?
No. Yeah.
Okay, I'm now going to mute myself audio. Yeah.
Rob, just to say, maybe you can mute your video or stop your video.
How do I mute a video?
Did the pop-up screen come up on your left when you move the mouse? There should be like a video.
I don't think you can mute a video. Oh, you can. There you go. Hang on. Yeah, I'll do that.
Sorry, you can mute the video. If you just look on your picture-in-picture, there you go, you've got it.
Mike, have I got your ear, Mike?
I can hear you, yes.
Are you doing something else? Because if you are, get on with it.
I'm not sure. I'm not sure at the moment, but fire away.
No. If you are,
understand. Just
what would have gone on with the tech, if that's what it was first thing. But if you're busy with other things.
Yeah, maybe can we do it in the wash-up? Is that okay?
Yes,
we had a couple of different things, but yeah, we will absolutely deal with it. I think we've got there's a couple of things out on.
That's no problem.
Fantastic.
Hello? I think 10 to 3.
Sorry, I think you may be unmuted there at the moment.
Sorry.
Sorry to just jump in, everybody, but just if you want to, I don't know if you do, you can mute out your camera. So on the left-hand side, if you move the mouse and you're picture-in-picture, you've got a little icon of the camera there, the first one. So just like you do with the microphone, you can mute the camera out, and that's what the clerk and defendant have done. So if that's, if you'd rather sit with the camera muted, feel free to do that.
Thanks, Mike. There's a juror who's having difficulties. Has that been resolved?
Yes, my understanding is she's involved in the conversation now.
Good.
Sorry, you're muted, Matt.
Is the public gallery closed at the moment?
Let me just check that.
If it's not, then we can have a chat.
Still connected, I believe. I think we've been asked to, unless you would like it disconnected, I think we've been asked to keep it open.
No.
Okay, fantastic. Thank you.
Thank you very much.
I'm going to mute my video lest some gossip comes into my head that I can't resist sharing with you and the whole world.
My internet. I've just spotted myself.
Sorry, you're unmuted. Just to make you aware, Your Honour, we've put a message on the jurors' screens just to give them a sort of 2-minute warning.
Oh, that's great. Thank you.
Would you like us to actually speak to them before we bring them in, Mark? I don't know if you're talking to us, Mark, but you're muted.
Me? Can you hear me?
Okay, it's Mark who I can't hear. He seems to be talking. Would you like me to go in and tell them that they're going to get brought back in, or?
Well, I did tell them it would be at 10 to 3. So if you tell them you are now about to go back into court or whatever, and then bring him in, that'd be fine.
Okay, fantastic. Thank you.
Could I just say that my internet appears to have broken completely, so I am now connected via my phone hotspot. But if I should go, it is completely internet related. So I'm sorry, it's gone. And I heard my son shouting about it, and he's gone, and everything's gone. So
well, the quality's good for the phone, so don't tell your son, because I suspect he'll commandeer it.
Yeah. Well, so I'll just stay on my phone for now.
Are we having a washdown, a Zoom or something?
I think there will be. Do we want to stay in here for it? I just might be.
Jodie will tell us, I think.
Yeah, let me not make those sort of decisions anyway. Yeah, okay. Sorry, I think something may be happening, Your Honour. Just bear me a second.
Yeah, sure. You have to ask, have you reached a verdict which are all agreed? If the answer is no, just leave it.
Sure.
Okay.
Do I have to ask them who the foreman is, or will you do that?
Apologies. I just to make you aware, I'm hearing that the deliberation is gonna run slightly longer. My understanding is the deliberation will run slightly longer.
Right. I mean, that's no problem to me. I mean, I've got nothing better to do with my time, but...
Well, actually, you may be able to deal with this. I think the jury would like some further guidance from you, so you may be able to help with that.
Okay, bring them in then, that's fine. Okay.
Yeah, fantastic. So we'll be bringing them in very shortly. I think
You're on. I'm off mute. Can you hear me?
Yeah.
Thank you.
So you may get a preview of the question, Your Honour. It's in the chat.
Yeah, I see it's arrived. My son has arrived. Let me see. Yeah. I'm not going to answer it because, well, perhaps I will if they got the time to give us. But the question is, can you all hear me? Can you both hear me?
Yes.
Rosina?
Yes.
Yeah.
Yeah.
The question is, good. At which point are we to consider when it was that Mr. Hallett believed that he was under attack or under the threat of attack? Is it the point at which he gets out of the car with the instrument, or is it at the point when he uses it? I mean, my provisional view is that, I mean, I'm not sure unless you're going to answer it, but my view is that that's the wrong question.
Well,
the question is
really answer it first, but
well, Your Honour, he got out. We say it's when he believed that when he was under attack.
I don't get what we say. What's the law?
The law is if he got out of the car, if he may have got out of the car to do no more than to reasonably remonstrate with the person who was being abusive to him, and he had the weapon with him, he's not doing anything unlawful at that stage. If, however, after starting to remonstrate, he then believed that he was coming under attack and he did no more than was reasonably necessary, at that time he's entitled to use the wheel brace. If he uses it instinctively, doing no more than is reasonably necessary.
Yeah. Yes, I follow that. Yeah. What do you say?
I'm just going back to your own paragraph, which I now, of course, can't find. Rather irritating. No, I've got it. So in relation to 7, your direction is accurate throughout. If you go to 7A.
Yes, but I understand that. But there's a prior question, isn't there? If the jury were sure that he left the car armed in order to launch some aggressive attack against the complainant, then the question of self-defense would not arise.
That would be right, and I would agree with that.
Right.
Correct.
Yes. That's plainly right. If he left, if the truth of it is he left with the intent, Tarek, yeah.
They're ready to come back in for the question.
Just hold them for a moment. Thank you. If he truly left the car to remonstrate, to seek an apology, and only used violence at a time when he was put under attack or believed he was put under attack by them, then he would have a defence, wouldn't he?
Yes.
Well, but in greater detail, either not realising defence counsel's speech that he was carrying it, which effectively I think was what he was saying, and indeed was put by Miss Cottage in her closing speech to the jury, or if he had picked it up, not intending to have it in any way, as to sort of...
Yeah, but that goes to the question of what his intention was, what his state of mind was. I'd rather use that phrase than intention.
Yeah.
His state of mind was when he left the car. Your case is the jury can infer that his state of mind must have been aggressive because he was armed.
I have two...
And because of what he did with the weapon. Sorry, you forgive me. You want to say something?
I have a double case, but they both feed into each other. It's the same part of a jigsaw, which is he stopped, he got out, and he armed. It's a triple case. So you take those things together, is what we say.
Yeah, but the essential question is, what was his state of mind when he left the car?
Yeah.
If his state of mind when he left the car was to remonstrate, to seek an apology, yeah.
Yes.
The case, your primary case fails.
Yes.
As it were. And the jury must, in those circumstances, judge the point at which the violence broke out, whether he was under attack or believe he's under attack.
Yes.
And then whether the amount of force used by him was reasonable.
That is the secondary case, yeah.
Yeah. That's the analysis, I think, isn't it?
Does Miss Cottage agree with that?
She does, I think, doesn't she?
Yes.
Yeah. Okay.
Yes.
So question one is, what was his state of mind when he left the car?
I did also, but my Wi-Fi is very poor, so I'm sorry.
No, I understand that. Don't worry. Yeah.
Yes.
Question one, when he left the car, what was his state of mind? If his state of mind was aggressive, then self-defense would not arise. Yeah. If his state of mind was non-aggressive, i.e. to seek apology, to remonstrate, then they would have to consider the position as it arose when the violence broke out. Yeah?
Yes.
Yeah.
Yes.
Okay, that's fine. Then I'll give them I'll ask them first whether they've got the time for this, and if they have, then I'll give them that direction. Okay, they can come back in then.
Okay.
There'll just be a minute.
Okay, that's good. Thank you. Can you all hear me, members of the jury?
We're missing a juror.
Juror number 3.
Yes. Yeah.
I think juror number three's camera is off. I think she may be there, but she may have just switched her camera off. I think that's on a local to her.
That's what checks, is it? Yeah. Right, those of you I can see, those of who can hear me, would you just give a thumbs up or a wave or whatever? Ah, see you all there. Excellent. Oh, then the invisible jury has reappeared. Good. Now, you sent me a question, which I'm very happy to answer for you. But the deal was that you'd be done by 3. But if you've got more time and you're happy to stay on a bit longer, then I'll give you the direction. Again, hands up. Are you happy to stay beyond 3? Is anybody here? Let's do it the other way around then. Is anybody not? Is that a not or a maybe? You okay? Good. Okay, that's fine. Right. I'm going to read the question and then. Well, I don't need to read it. You know what it is. It's if I may say so, a perceptive and sensible question. There are sort of really 2 questions here. The first question is the state of mind of Mr. Hallett at the point he left the car. If his state of mind at that point was, as the prosecution say, aggressive, he was really looking for a physical, violent confrontation. And the prosecution say that he was, because the inference is inevitable that he'd left the car when he didn't have to, and he left the car armed. That's how they put their case. If you were sure that he left the car in that aggressive frame of mind, looking for a fight, then he couldn't possibly be acting in self-defense. So if at that point that was his state of mind, then the question is easily answered. If, on the other hand, you think that he may have left the car with a different frame of mind to seek a non-violent remonstration or apology without violence, then you would then have to consider what his state of mind was at the point the violence actually broke out. Does that make sense? So essentially, I think the question would be who actually started that violence? Was he acting to defend himself from violence launched against him? Is that so, or may it have been so? Or was he himself acting aggressively, starting the violence? If the answer is you're sure that he was acting aggressively at that point, then he would be guilty. If you weren't sure of that, then you'd need to go on to consider the next question as to whether the amount of force used by him was reasonable. Does that make sense to you? Good. I'm glad to hear it. All right. And I'm sorry to have kind of rather rushed over it because it was at the heart of the question you would ask me at the end of the summing up, but I was very keen to get you into deliberation. But there is the answer. And I don't want to trespass on your goodwill and your time. Now you've got that direction. If I were to give you another 10 minutes or so, would that make sense to you? And I'll give you longer or shorter, but I'm trying to think of your time. Okay. Well, let's stretch it a tiny bit. It's just after 3 o'clock. I'll bring you back at 3:15. How's that? Is that good? Good. If you've got a verdict, we'll take it. If you haven't, then that's okay too. We can also live with that. Okay, then I'm going to send you back to your virtual space. Good. Both happy with that? That, I think, encapsulates what we said.
I've sent an email, just a separate topic.
Yeah, but are you happy with that direction?
Yes, thank you.
Ms. Cottage, you happy with that? I'm not sure you're hearing. Ms. Cottage, can you hear me?
Rosina?
Thank you.
Yeah.
Thank you.
Can you hear me all right?
I'm happy with that. Yes, I'm going to leave the meeting. Yeah, I can hear you.
Yeah.
I'm going to leave the meeting now to try and sort out my Wi-Fi.
Yeah, sure. Understood. Okay. Thank you.
3:15.
3:15. Yes. Yeah.
Thank you.
Have you been busy, Mark, or?
I think the public gallery's open.
Ah, sorry.
I'll check with the guys. I think it's open in the usual way.
Yeah, it's up and running.
Thank you.
Unless we're told otherwise, thank you.
Well, not engaged at the moment.
I'm back. Hello.
Hello, everyone's just dropped out. I think.
I've just back on myself. Can you see and hear me all right, Rosina?
Yeah, I can see and hear you, but I've lost Mark and I've lost Robert.
They've both dropped out.
Oh, fine. Okay, yes, my Wi-Fi's back on now. I don't quite know what's going on there anyway.
Good. You didn't hear the jury direction that I gave in that case.
I did. I heard enough to know that is what we discussed, and I wasn't. I had nothing further to add. Thank you.
Okay, I was going to deceive you as to what I'd actually said, but
were you? I'd heard enough, I think.
Good. Okay, I'm going to go invisible and quiet while the jury arrive.
Fine. Me too.
I didn't. You pick up. I didn't. At 3:15, I said you heard
yep,
that.
I heard. Thank you. Got that.
Good.
I would have thought. I would.
not sure if you can hear me, but we're just popping up another 2 minute warning for them on screen. I think they've got 3 minutes, but it'll be 2 minutes by the time they've seen it. So we're just giving them that update now.
That's great, Mike. Thanks very much indeed. Thank you.
I think we may have something actually. Give me a second.
Good.
I've turned my microphone on so it can be heard now. Can you all hear me?
I can, yes, thank you.
And I have too.
Good, can hear you.
Thank you.
That's still your Wi-Fi, is it?
It's back to my Wi-Fi now, yes.
Yeah, good, yeah, good.
Okay, I'll be bringing them back in 1 second.
Yeah, that's fine. Yes, they're ready to come. I see that. Thank you. The jury being kept back for some feedback, are they? Do we know?
I'm not sure.
Sorry, was that a question for me?
Well, for anybody who knows the answer, do you know, Mike?
What was the question?
Are the jury being kept back for a bit to give some feedback? Or
I think I think we did the same last time. We're going to let them have a little bit of time to have a kind of wash up and have a chat together. So we'll do this bit and then we'll drop them out and give them a bit of time there to do that.
That's fine. Yeah, sure. But they've got more to do today before they go home. Well, they are home, but before they.
That's my understanding. I don't think we're going to necessarily ask them to fill out any forms, as far as my understanding is, but I think that's where we are.
Sure. It's just to know what to say, that was all. But thank you. Yeah. Sorry, just to help you, when you ask the jury whether they reach a verdict in which they're all agreed, I'm prepared to bet a significant amount of money. The answer will be no. Just a hunch.
Okay.
Any takers? No.
You're going to give a majority?
I'll give you odds if you want. No.
What makes me think of my... Will Your Honour, in the circumstances, they have not all reached a decision. What do you want to give
I'm show of hands, yeah, I'll ask. Yes.
Majority direction.
Yeah. No, I won't do that, but I'll ask for a show of hands, just see where we are.
I think they'll be coming in a minute now.
That's perfect, good. Okay, good. Good. Well, welcome back, members of the jury. The court clerk will ask a question of your foreman, your spokesman. Who speaks for you? Could you raise a hand? Your foreman? Did you get one? Oh, yeah, go right. Thank you. Juror number one. Thank you. Yeah. Did you ask a question?
Yes. Madam Foreman, please answer my question, yes or no. Have the jury reached a verdict on which you are all agreed?
No.
Okay. Thank you very much indeed. For the purpose of this exercise, I will leave it there. I would have otherwise given you more time and so forth, and ultimately majority direction, but that's not going to arise. There are more questions, I think, that you're going to be asked by those running all of this, so I'm not going to say you can go home. Well, I mean, you are home already, aren't you? But I mean, you're not quite free to go yet. I'm going to ask you, if I may, and no need to reply, just as a matter of interest, perhaps there's some of you who are still thinking about it and haven't reached a view, provisional or otherwise. But if that's so, then no need to vote. But how many of you at the moment were inclined to convict? Hands up, convict us.
1, 2, 3, 4, 5, 6.
Yeah. Counts, yes, the prosecutor counts. And inclined to acquit? And a couple of you were still mulling over one way or the other, still had open minds. Yeah. Very interesting. Thank you very much indeed. Well, as far as this trial is concerned, thank you very much indeed. Others will thank you for the important contribution you've made to this project. But from the kind of judge's point of view, you've been great. You've listened carefully and asked sensible questions. And thank you very much for that. I think you're now going to leave the courtroom space and go somewhere else for some sort of a wash down. But it's been good to see you all, and thank you all very much. Now, I'm not sure where we go.
I think the public gallery is still...
All right. Yeah, well, if we could close the public gallery.
We'll close the public gallery for now, yes, yeah. Bear with me 1 second.
Okay. I can see the potential problem that Jodie is
the jury.
Neither one thing nor the other. Well, she's not one thing or the other. She's two things. And I don't know whether she wants to be with the jury feedback stuff or with us.
Would it be inconvenient, or would it be a reasonable idea, Tarek? I guess you may know more through Andrea and others.